But right now is the time.
Special meeting to order at 6 p.m. There is a new Nebraska Opens Meeting Act, so we don't have a big poster, but there's little sheets. If you want one, you can come look. Closed session, if during the course of the meeting discussion of any item on the agenda should be held in a closed meeting, the board will conduct a closed meeting in accordance with the Nebraska Open Meeting Law. Roll call, please.
Mr. Benish.
Here.
Mr. Ernest is absent. Mrs. Ernest.
Here.
Mr. Shoemaker.
Yes.
Mr. Wiedemann.
Yes.
Mr. McLaughlin.
Here.
Mr. Jones.
Here.
Do we have any communications? Can we do pledge allegiance? I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Approval of the agenda. So moved. Okay. Presentation to the board from Justin Knight about our track. Oh, roll call, sorry.
Mr. Benish.
Yes.
Mrs. Ernest.
Yes.
Mr. Shoemaker.
Yes.
Mr. Wiedemann.
Yes.
Now presentation to the board from Justin Knight on our track.
All right. Well, Justin, I can kind of set this up if you'd like me to. So our meeting tonight's going to go presentation by Mr. Knight. He's our legal counsel for the track project. And then following that, we're going to have a public comment session for the public to make a public comment if you'd like to. So Justin, this is kind of the culmination and what do we do next on the track. So with that, go ahead and get started. Well, thanks, Matt, and good evening, everyone, and good to see you all. I'm going to go over what I would call like a 10,000 foot overview of kind of where we've been, how we got to where we are, and maybe some next steps or options or things like that. Can you hear me okay?
Yeah, we were just getting some feedback on our end.
So, and I say 10,000 because, this is a lawsuit in progress. So in terms of the attorney-client communication, that's really got to happen in closed session with strategies and specifics and things like that, because from the board's perspective, obviously you don't want to be, saying something where if somebody who's involved in the lawsuit heard it, we basically give away our cards or anything. So just kind of taking a step back and looking at everything. This is a track project that was constructed years ago, quite a bit of while ago. We filed our complaint in March of 2024. So we're 16 months in. And the unfortunate reality, I guess you could call it, of litigation is it just takes forever. There's a lot of hurrying up and waiting. So we got everybody served when the board voted to move forward with actually serving the defendants. And so in August of 2024 is when the defendants, Reichert, who was the general contractor, Hughley, who was the architect, and Fisher Track, who assisted the district with the track project. Between August and actually October, each of those three defendants formally answered in the lawsuit. After that, it became a really more of a process for Mr. McLaughlin than anything, because the defendants served discovery requests on us, written discovery, we served discovery on them. So written discovery would be requesting documents from the other side, asking questions that are called interrogatories that require more of a narrative, and then request for admissions, which is an admit or deny questions out of that. Between probably October and March, and even April, I think Mr. McLaughlin and I spent quite a bit of time going through documents and finding what was there and answering interrogatories. And so that's kind of culminated to a lot of, that sort of set the stage for a lot of things, because the documents can tell us one thing, but in terms of actually hearing something from somebody who is involved, that's a whole nother level. So we had been working on everything, and then we had the attorneys in the case had a status conference with the judge on April 8th, and the judge just kind of wanted a quick update to make sure things were moving along, and they are, and so all was good. But prior to that, the Riker group, the general contractor, filed what's called a third-party complaint, or they've been sued by the school, so they're now turning around and suing somebody else, saying if something went wrong with us, it was because of this third party. And that third party is Simon Contractor, who Riker is saying if something was wrong with the milling of the track, evidently it was Simon Contractors who didn't do it correctly, so that they're going after Simon Contractors. So at the hearing on April 8th, we really couldn't do much because we were waiting on Simon Contractors to get involved, because if they're going to get involved, surely they're going to want to do similar discovery as everybody else has done. But Simon Contractors never answered, so we don't know where they are, we don't know what's going on with them. On May 27th, Riker filed a motion for default judgment against them, meaning they had 30 days to respond, but they didn't. So we're kind of waiting on the court to make a decision on whether to grant that or whatever the court decides to do. So that's kind of a really brief synopsis of something that's been going on, and there's always been something going on for some time now. So that we're kind of to the point here, and I'm just talking generally here without any specifics, but we're kind of to the point here where we need to decide, are we going to push through and continue with discovery, which can be depositions and a lot more involved discovery to get it ready for trial, or a possible mediation, which the court will typically order to see if it can get resolved without a trial. If we're going to proceed with the lawsuit, that's where we have to go at this point. With the caveat being, though, that if that's the direction that the board wants to go, there is a cost to all of that. We're probably looking at between 15 and 20 depositions that's going to require, including Mr. McLaughlin and maybe others in the district, that's going to involve some preparation and times in those depositions and things like that. So we're kind of at the point where we've done what we can up until now, with the hope that we're not spending more money than we need to, just not knowing where all of the pieces are going to land on this. But at this point, we probably need to have some kind of a conversation, or maybe it's more of a strategy session in closed session, but kind of getting to the point here where we're kind of at a fork in the road. I don't know if we only have two choices, but we got maybe 3 or 4 where we need to probably decide what to do and get working on that over the next 2 or 3 months.
Justin, can I ask you a question?
Hang on just a second.
Oh. Can you hear me?
Now,
Okay. Would it be possible for the people who are here in the audience to just do kind of a brief discussion or explanation maybe as to why we're doing this? The information that you gave was great, but I don't know if people understand our purpose for filing.
you mean related to the track,
Yes,
the initial, the problem?
Yes. yes.
Yeah. So, the track, for what is it now, 5-year-old, 6-year-old track, from what I've seen, it does not look like a 5 or 6-year-old track. It looks like maybe like a 55 or a 56-year-old track, where we've got photos of grass literally growing within the track itself. So cracking, concerns about unevenness, concerns about why in where the track was built, why we've got fences and light poles so close to the outer lane. There's a list, and I've got it in my letters, got a list of things that really don't seem like what you would expect when you put 7 figures into a brand new track. So we've had those concerns. I know Mr. Laughlin and maybe a board committee has tried to reach out to the individuals that ultimately sued. The responses from those individuals have been somewhere between not even responding at all, not attending meetings that were scheduled, kind of pointing the finger at somebody else, or not really seeking to accept the extent of that. So really, we tried to resolve this before we got to where we could come to a compromise, and that's I don't think it's a win-win, but it's certainly better than being stuck in a lawsuit for years. Nobody was willing really to come to the table. And so under Nebraska statute of limitations, we had to decide back in 2024, either we file a lawsuit and we proceed and move things along, try and get something for all of the problems, or if we don't file a lawsuit, the statute of limitations runs, and then the board makes with what it can, because once the statute passes, there's no remedy at law available. So I don't want to be dramatic and say we were forced or we had no choice to file, because we couldn't, we didn't need to, but we decided we would preserve our right to file, hoping that maybe that would get some attention, and it probably has. But at the same time, with the amount of money that went into the track, I think if we're going to continue it, we probably need to push things further along the next couple of months to bring people to the table, I won't say more aggressively, but start getting going on depositions and things that probably are going to get more people's attention.
Thank you.
Is there anything else we want to discuss, or you want to talk about, Matt, before we?
I don't know, I think you did a pretty good job of explaining kind of what brought us here. And kind of,
They're the ones that brought it to us.
yeah,
A lot. I mean, that's kind of what got our attention on it. We had a meeting, a few of us, there were some people from the school that work here in administration, and they were like, your fence shouldn't have been here, your light pole shouldn't have been here, your bleachers shouldn't have been here. So then right away, that's when we had Matt start investigating, and the more we looked, the more we found wrong.
yeah, it was kind of like, I think it was one of my first days on the job. We were trying to get somebody out here to look at the track, just because we knew that we were going to need some top coat stuff, and we also had some questions about cracking and things like that with the track. And when they came out, they said you should not even use lane 8.
They told us to kid, like,
Yeah.
don't do it.
Just don't even use lane 8. So when they said don't use lane 8, we immediately started looking at canceling track meets. So it cost us a district track meet on a couple of different occasions. Yeah, we could have had 2 district track meets here.
And if we spend $1 million on a track, we have to take care of that track. We have to do our best to do what's right by our taxpayers. And now we're at a,
What do we do?
what do we do? Where do we go?
You have anything? Questions?
Anything to add other than
Yeah,
this?
No, that's, just thinking that's the majority. It's a risk. Moving forward's a risk.
Yeah,
Because there's no guarantees we'll get a dime out of anybody. But if somebody messed the track up, they should pay for it.
We don't even know what we really have.
Well, we don't wanna screw around with the taxpayers' money and come away with none of it.
Yeah.
That's, it's a big risk.
It's a huge risk. So we wanted to get some opinions from folks, and yes, we really appreciate you guys showing up today. Justin, would you mind if we did our public comment, and could they ask questions, and would that be all right?
Sure, I mean, I can answer them to the extent I can, if I can, because it's background with attorney-client relationship, I may have to respectfully decline, but that's fine by me.
Cool. I guess you guys good to move on? Okay. We'll do hearings and persons to address the board next. Leyton Board of Education recognizes the importance of citizen participation in school district matters. Only those speakers recognized by the board president shall be allowed to speak. A time limit of 5 minutes per speaker is allowed, and no more than 20 minutes will be divided among those who wish to address the board. We're going to let everybody talk for 5 minutes. There won't be a 20-minute limit. Defamatory, abusive remarks are out of order, and the speaker will lose his or her privilege of address if such conduct or remarks are made. The speaker at a board meeting will not orally initiate charges or complaints against the district employees or challenge instructional material used by the district, but shall use the appropriate board policy to process such complaints. The superintendent and board are not subject to questioning by the speakers. To speak to an agenda item at an individual, to speak to an agenda item, an individual must stand and be recognized by the board president, state your name and address, state your agenda item to which you speak. Your name will be placed under the agenda item, and you will be called upon to speak when that topic is up for discussion. If the speaker has written or printed materials to be circulated during a board meeting, he or she must have submitted this information to the superintendent no later than the Friday immediately preceding the Monday board meeting. Written materials not submitted by the deadline will not be reviewed or considered by the board at this meeting. The board takes no action on items brought up during this time. The board and the superintendent may question a speaker or make comments in response to a speaker. However, the board and superintendent are not subject to questioning by the speakers. Would anybody like to speak?
If you have questions,
Well,
especially
I just have some questions.
Perfect.
What exactly?
Can you stand up and give us your name and where you live, please, Bernice?
Bernice Russell.
Thank you. Thank you.
Well, I know the fence thing has, that Lane 8 has been a problem ever since it was built. But what can they do, in this lawsuit, what would they do to correct that?
Fix it.
But how would they fix it? You know, can they fix it with what we have built there? Can they still, would the track still be usable? And how would you fix it? You'd have to.
I'm not an engineer, I don't know.
I think, and we've talked with Justin about this, is that because of so many things that were done wrong, the base is wrong, I mean, it's like they all just decided not to do it correctly. And I don't know if you guys are, I'm hoping that they'll come up and say, yeah, we did this wrong, we'll just redo it for you. At which case then they'd move things. I don't know if that will ever happen. But
So the surfacing was part of this
that was
problem.
kind of the beginning.
Yeah.
That was the beginning. I mean, we were all concerned about Lane 8, long time ago, Lane 8. But
It's peeling
Yes,
in places, there's holes in
it's,
it.
like
These
you
guys
said,
could
yeah,
probably-
it's doing things that it should not be doing at this stage of the track.
Plus the,
And do you have a figure of what it would cost the district to get the repairs done and done right?
Well, just to do our maintenance that we have to do with it, like between 5 and, is it 8 years, something like that? It's a resealing of it for $100,000. And that's every
5 to
9,
8
10, yeah, 5 to 8
And
years.
compare that to what it's going to cost you to go to litigation.
What did he say?
And
26,000? Is that what you
On
thought?
the cost of litigation, is that something that we can just say what we're estimating?
Well, yeah, so if we go forward with full discovery, it would be probably between 100 and 150.
No.
And we, how much have we spent already? So we're honest.
We could,
I think it's 7. Is it 70 maybe? Does that sound?
I don't think that.
Not that much.
I don't think it's that much.
But going to litigation, you're not going to be promised that there's
Not-
going to be.
Correct.
It's just that you're not promised a thing. That's
So-
my fear is.
That's why we're doing this. We don't know what to do.
Yeah, well, that's why I was asking about what the cost of repairs would be. And the reason I had these questions is because my granddaughter put up a new house, and she's got all kinds of problems with it. And when she had somebody come in and tell her she was gonna go to litigation, and when she had someone come in and tell her, look and give them an estimate, it was cheaper for them to fix it themselves than it was to go through litigation. And we're talking about $100,000 too.
But we can, like we said, the top coat would fix it for 5 to 8 years, but that's just the track surface. It doesn't change the fence, doesn't change the light stands, doesn't.
The milling underneath.
And it doesn't
the track
change the
itself.
base.
It's the base, and so the base is never gonna go away. I mean, it's under there, and it's gonna have to be fixed every 5 to 8 years, I suppose. And I don't know, in another 5 to 8 years, if that top coat would even fix it. So,
And this top coat went from 60,000 to 100 and whatever we accepted. 90, so right at 100, so I mean, it's in that little amount of time, that just keeps.
And how big of a chance do they think we win if we do go there? I mean, it's a guess.
Justin,
Still,
give us your odds.
Looking for 40, yeah.
they sometimes have a kind of a percentage or something, you know?
Yes.
How often do these things, do you come out ahead?
Yeah, I don't know.
And Justin, do you feel comfortable with giving an estimate on our odds here?
Not until we, that's kind of why we need them for more discovery. To your point, we don't know what we don't know, and some of the people that were instrumental in making those decisions aren't around anymore, so we have to take a bunch of depositions and find out who approved what or didn't approve what at the time, and until we know more of that, it's pretty hard to handicap it.
Was there formal approval made at the time, they were done? And then we found out all these things after?
We have no paperwork from the track, we're done, here are the keys to the track, take good care of it, this is what you do. We have none of that.
We know nothing on our
We
own
have
facility,
nothing.
is a way to.
We
yeah,
don't
there's-
have a warranty, we have.
Well,
no paper.
that's what Tony was just saying, there's no warranty on their work.
We don't know, and as of this point, I don't know if they told us. It's, I don't know, I don't know what to do. Yeah, none of us were on the board at that point.
I mean, it's $1 million track. I don't think anybody wants to see it just go to waste.
No, I don't.
At what point do you say, well, we can't spend $200,000 of the taxpayers' money on a hope and a prayer? Just hoping that somebody says, yeah, it's my fault, we'll fix it. I'm not saying that wouldn't happen, I'm not saying that you wouldn't win a lawsuit, it's really taking a chance with a lot of money.
You had raised your hand earlier, did you, Melissa? Okay.
But nobody wants to see the track go to waste,
No.
that's crazy. Because it is a beautiful thing, the whole facility is. We're not gonna let it go to waste, even if I don't feel like we are, even if we
No.
don't pursue the lawsuit, we're gonna find a way to take care of it.
We just don't know.
I want them to pay.
Yeah. I want, yeah.
I don't want to spend 6 figures and come home with nothing.
Anybody else like to talk? Matt, can you state your name where you are, please?
Matt Gillespie.
Thank you, Bernice.
611 Francis Street here in Dalton. First question, I know you're not supposed to ask questions, but with the fence and the lighting and the hazards associated with that, is that a code violation? Is that an ordinance? Is that something set forward in the state? Or is that in writing somewhere that says that that cannot be there? And how is that worded?
It's not the NSAA, not an NSA requirement, but it is listed in the, if you remember what the,
NFHS, I believe.
you know, International Safety Code.
Okay, so through the IFS.
It's a guideline, though.
It's a
Okay.
guideline, it's just a recommendation.
Yeah, but does it say should or shall on it? Because should is you've got to do it. Yeah, and shall. So, I've worked construction for 25 years as an engineer. You're looking at, I thought when we put this in, we knew that it was gonna have to be resurfaced every 5 to 10 years.
Yes.
Now, I know prices are you can't forecast the prices, especially lately. But in my line of work, and anybody in construction, you give a warranty, and that warranty is an X amount of time. But quality, a warranty is for breaking of materials. You know, the lights fail, a pole falls over, the fences, somebody gets hurt because the bleachers fall down, something like that. That's covered under a warranty. But you have to go through, for something like this is a design issue, is, you know, I have to keep all of my records for 20 years, I'm liable. Even though my, you know, my liability insurance is only good for so long, I still maintain an E&O, which any engineer has to cover umpteen $1 million for mistakes that may be made in oversight, which is what this was, an oversight. And this should have been on the architect, structural engineer, and civil engineer. So who was it that dropped the ball on this? And are they going to stand behind it in their insurance company? Has anybody talked with their insurance companies, or is it still in the stages where they're talking to their insurance company and we haven't brought them in yet?
Well, their insurance companies are the ones defending them now.
Okay.
And like I said, we don't have any of that paperwork that you just mentioned.
Yeah.
that we
Well,
should-
our entire staff at Leyton has changed. I mean, pretty well 80% of the school board has changed, if not all of it, and all the office staff. You know, our superintendent and our principals, athletic directors have all changed, everything like that, I think, since this has been built. So,
Well, he's just changed his
yeah, but he
title.
was an athletic director then. But, you know, emails, anything like that, trackable. Because I know a lot of people brought it up with this track that it was cracking when they put it in, and there was direction where we could direct our comments at towards that. So,
If there's emails, we'd love to see it.
We'd love to see anything
Yeah.
about anything about that facility. Anything from anyone. Yeah. And we agree with you.
It's no secret when we had asked the architect for any emails associated with it to just talk about the different phases. There was some kind of server error, and they couldn't find any of his emails.
They're all gone.
Hillary.
Exactly.
It's just
A bit of bleach.
those are the things that are really
At first, we reached out, hey, can you just tell us what we have? Can you give us something to kind of fill us in? And then that just led to.
That's that big red flag that they see coming down the road, so.
And they refuse to give us anything,
Oh, yeah.
anything. Not even just,
Until you get to
Here's what
this
you do.
stage,
yeah.
and until it's subpoenaed by a court order, they're not gonna hand it over.
You good, man?
Thank you.
Yeah, thank you. Anybody else?
Ron Floor, 816 Elm Street. So if you decide not to go forward, where are you gonna get the money?
Decide not to go forward or to go forward?
If you decide not to go forward with your lawsuit, not to continue your lawsuit, where's the dollars coming from and how are you gonna handle it?
That's another good question.
That's a good question.
That's why we're hoping to get as much input and
Yeah, but input's one thing and money's another thing.
So how do you, I mean, how do you feel like we should go after them? Or?
I don't have a dog in the fight.
But
Well,
you
you
do,
do,
you're
you're
a
the
taxpayer.
But- But if you gotta come up with an alternative if you're not gonna do something. You gotta make a decision. Somebody made a decision and it was the wrong one, okay? We realize that. Now, how are we gonna fix it?
Well, I would
If
assume
you're
we
not
have
gonna go forward with the lawsuit, then you need to sit back and say, okay, we're not gonna do it, we're gonna fix it right, or we're gonna get Band-Aids.
because that's what we're afraid of.
How much money do you have to fix it? That's my question right now.
Yeah, we've budgeted for the top coating, so that's 97,000, 96.5, something like that. So we budgeted for that repair, the top coating, but moving the press box.
That's not gonna fix that lane 8.
Yeah.
And you're gonna continue to have that problem with the street? NSAA,
And, you know, I'm sure there are grants out there that are, I mean, we can find,
The simple answer is
Something.
we raise the levy to pay for it. I mean, that's just blunt. You gotta, that's how you create money. It's, right? So if we were to fix it right.
it takes a pretty good mill levy.
It would.
It
right?
takes that, yeah.
Yep.
I think the simple answer is we don't, as a district, have enough money to start over with $1 million project.
Right.
We can't do that. So is it worth the risk of 150, 200,000 to go after these people? Could we eat that over, if we get nothing, we're gonna have to eat that too?
So where's the money gonna come for that?
That's what
No,
that's why
I'd
it's
say,
a- That's why it's a risk.
either you have money to proceed, or you have money to fix it. Or you have no money and it stays as is, and it's just a great big oval out there.
I agree.
and I wish we could tell you that answer. I mean, because regardless, if we'd have to, I mean, it'd have to be either torn up or parts torn up to match, to fix the things that are underneath it, because it's not just lane 8 and it's not just the fence or the pole, which would be relatively simple. Unless you know of asphalt guys who'd like to come give us a, you know, yeah, give us a little help, or some guy in construction that can level the track part so that we can redo it.
You know, our buildings are also aging. We have older buildings that need work constantly. When we do our facility walkthrough, we're looking at $500,000 in just repairs, blowing cold air on us right now. So we just need some guidance, I think.
The thing is, in the end, we have to make a decision. And we can sit here and say, well, we don't really have the answers, but we have to. So it'll be on the board to decide that. but we'd like as many opinions from the public as possible. Not gonna please everybody, I'm sure.
Do we go, how far do we go? You know, I don't know if we can stop once the discovery, before, I mean, once we find the discovery, can we be like, yeah, well, and then stop that, Justin, or is that,
Yeah, we're defining it, so you can pull the plug at any time.
So if we start down the road of discovery and we're not discovering anything, you can say, this is a loser, guys. We can
Yep.
just pull the plug.
Yep.
One other question. Are you planning on including legal and court costs in this expense when you go? If you go?
Justin had given us so I don't think we can include the court costs and legal into the lawsuit, just by Nebraska statute. Is that correct, Justin?
Yeah, yeah.
So we eat the court costs and the legal fees?
Yeah.
Well, he didn't do it for free, right?
Anything else, Ron?
I'm fine.
Sorry about that, Ron.
I'll get you later.
Yeah, I know you.
I guess, is your opinion that, you know, well, we spent $1 million on it, do we spend a little bit of money to try to get that going, or do we just make a second plan on how to fix it?
I'm not sure you have an alternative, but not to go forward.
I kind of feel that way too.
I think it's tough because, right, it's not the school's money, it's the taxpayers' money, right? It's the stakeholders' money. So that was $1 million of yours already used. There was good feelings about it, there was hard feelings about it. It doesn't matter anymore, we have the facility.
Yeah.
Right,
It's
nobody
clear.
abandons $1 million house or whatever they build, so how can we do right amongst our stakeholders to make it right over there? That is what we're trying to figure out. What is the best way to go about that? Anybody else? Good, okay, we'll move on. We will move on to the regular agenda. Can you roll call, please? Sorry, roll call that one, or just? for
Yeah,
the-
just
Okay.
motion to excuse the member.
I
Okay.
would make the motion, we excuse Mitch Ernest for tonight's meeting.
Roll call, please.
Second.
Second.
Okay, Mr. Benish,
Yes.
Mrs. Ernest,
Yes.
Mr. Shoemaker,
Yes.
Mr. Wiedemann.
Yes.
Review, consider, and take action regarding on how to proceed with litigation on the track. I feel like closed session would be appropriate at this time, Justin. Are you?
Good.
Okay.
Good.
Yeah, I was gonna try to find the statement for you. Do we have a motion to enter executive session?
I would make the motion, we enter closed session at this time to discuss pending litigation on the track project.
I would second that.
Roll call, please.
Mrs. Ernest,
Yes.
Mr. Shoemaker,
Yes.
Mr. Wiedemann,
Yes.
Mr. Benish,
Yes.
6:39.
Thank you, Janelle.
Make a
No,
motion.
we don't have to.
Don't we
Don't
have
have
to
to.
write
No,
just-
no, we don't have to do
Okay,
that. anymore.
perfect.
I would make a motion that we instruct Justin Knight to find a expert witness for the purposes of examining the track.
Is there a second?
I'll second.
Roll call, please.
Mrs. Ernest,
Yes.
Mr. Shoemaker,
Yes.
Mr. Wiedemann, Mr. Benish,
Yes.
Informational items, the next regular meeting will be next Monday. And I believe that's it. Do we
6
have-
o'clock.
Is it 6? We sticking to 6 again?
Yeah.
Awesome. That'll be 6 next Monday.
I'll make a motion, Jim.
Second? I'll second it. Roll call, please.
Mr. Shoemaker,
Yes.
Mr. Wiedemann,
Yes.
Mr. Benish,
Yes.
Mrs. Ernest.
Yes.
7:02.